All right, so good evening, afternoon, morning, depending on when you're watching this. Thanks to those of you who are watching. Thanks to those of you who are joining. I appreciate you making the time. Welcome to our workshop on May It Please the Court. This workshop is new, and it's focused on exploring the interaction between the U.S. Supreme Court and federal, state, and/or local policy and political institutions, actors, and behaviors. The live Zoom is held on Tuesdays from 8 to 8:30, and this is our schedule. So we just finished listening to case one last week, which was Tennessee versus Mississippi. It was a case about water. And the next 4 weeks, with the break at the Thanksgiving mark, we'll be listening to case two. And our case two will be the United States versus Texas. So we'll go ahead and jump to Supreme Court case two. And this will cover weeks 6, 7, and 8. And obviously there's a Thanksgiving break in between weeks 6 and 7. So our learning objectives with this workshop are to be able to describe a mind map model for a case. Secondly is to identify the facts of the case, identify the question or questions of the case, and then identify at least 3 interesting aspects of the case. And what we'll do over this meeting, the next meeting, and the following meeting is listening to the oral arguments that are made before the Supreme Court on the case itself. Now, recall that we have this mind map model for a case. It's basically the different elements of a case: the name, petitioner, respondent, docket number, decided by, lower court, citation, advocates, when it was granted, when it was argued, the facts, and the question. And I use this visual representation of it because I think it's just helpful to know that these are all the elements of the case that you want to keep in your mind as you're learning more and more about Supreme Court cases. So the case we're going to be starting to hear today is the United States versus Texas. The petitioner is the United States. So this was the person or the entity that asked the Supreme Court to hear the case, and the respondent is the one responding to the petition, in this case, Texas. And in other words, the United States is suing the state of Texas for some action it's taken. Now, next, we'll listen to the facts of the case. I'll go ahead and read this out loud. The Texas legislature passed a law known as SB8 that prohibits abortions after about 6 weeks of pregnancy. Additionally, the law criminalizes any person who, quote, aids or abets any such abortion and permits any private citizen, as opposed to the state itself, to file a lawsuit for damages against such persons. Abortion providers challenged the law, and the U.S. Supreme Court rejected the providers' initial request to block enforcement of the law. After the law went into effect, the providers filed another legal challenge, as did the federal government. A federal district court temporarily enjoined enforcement of the law, but the U.S. Court of Appeals for the Fifth Circuit stayed the lower court's injunction. The Department of Justice asked the court to reinstate the district court's judgment. Now, the question that the Supreme Court is being asked to answer is, can the United States sue the state of Texas in federal court to prohibit enforcement of an unconstitutional abortion law? So let's go ahead and listen to the beginning parts of this oral argument for as much time as we can, and then we'll have a discussion that will be the unrecorded portion of our workshop. So let me go ahead and open up that. And let me just stop sharing my screen really quick to make sure the audio is working correctly. Here, share sound. Okay, good. Okay, so here is OEA, the website that serves as the repository of almost every Supreme Court case ever, and all the audio recordings when they started to record them, I think back in the early 1900s. So let's go ahead and listen to this case.
We'll hear argument next in Case 21-588, United States versus Texas. General Prelogger.
Mr. Chief Justice, and may it please the Court. Texas designed SB 8 to thwart the supremacy of federal law in open defiance of our constitutional structure. States are free to ask this Court to reconsider its constitutional precedents, but they are not free to place themselves above this Court, nullify the Court's decisions in their borders, and block the judicial review necessary to vindicate federal rights. As this case comes to the Court, there are 3 principal questions. First, is Texas responsible for this law? Second, can the United States sue to hold Texas to account? And third, is the injunctive relief available? And the answer is yes, down the line. Texas is responsible for the constitutional violation here. It enacted a law that clearly violates this court's precedents. It designed that law to thwart judicial review by offering bounties to the general public to carry out the state's enforcement function. And it structured those enforcement proceedings to be so burdensome and to threaten such significant liability that they chilled the exercise of the constitutional right altogether. The United States has a manifest sovereign interest in suing to redress this violation. SB 8 is a brazen attack on the coordinate branches of the federal government. It's an attack on the authority of this court to say what the law is and to have that judgment respected across the 50 states. And it's an attack on Congress's determination that there should be access to pre-enforcement review in federal court to vindicate federal rights. The United States may sue to protect the supremacy of federal law against this attack. Finally, the injunction is a proper response to Texas's unprecedented law. If Texas can nullify Roe and Casey in this manner, then other states could do the same with other constitutional rights or other decisions of this court that they disfavor. Federal courts are not powerless to craft relief to stop that intolerable threat to our constitutional hierarchy.
General Prelogger, would you spend just a few minutes on the United States interests that gives you a basis for being involved in this suit?
Of course, Justice Thomas. The interest of the United States here is the sovereign interest in ensuring that states cannot flout the supremacy of federal law by enacting a law that's clearly unconstitutional and then through this simple mechanism of outsourcing enforcement authority to the world at large, blocking the traditional mechanisms for judicial review that Congress in Section 1983 and that this court in Ex parte Young recognized would be vital to securing federal constitutional rights against that kind of law.
Is there any difference between legislation and precedent of this court as far as the supremacy interest that you have?
I think that if a state structured a law in exactly this manner to try to flout this court's precedents, for example, interpreting statutes, that it would raise that same kind of supremacy concern. But of course here I think that the situation has additional urgency because what Texas has done is taken constitutional precedent from this court and legislated in direct defiance of that precedent and then tried to, in the words of the interveners, box the judiciary out of the equation and prevent the courts from being able to provide any meaningful form of redress.
You based your involvement quite a bit on Debs. Can you give me a couple of examples where the United States has taken a similar action based on Debs?
I'd be happy to. And I want to acknowledge at the outset that we can't point to a case that looks exactly like this one, and that's because there has never been a law exactly like this one. No state has ever sought to challenge the supremacy of federal law and keep the courts out of the equation in quite the same way. But I think that there are relevant principles to distill from the Debs line of cases. And what the court has said is that the United States cannot come in and seek to intervene in a merely private dispute. It needs to be acting on the basis of the public interest and the public at large. And that further, the subject matter of the suit has to be one that concerns and is entrusted to the care of the nation as a whole and for which the nation owes a duty to her citizens. And this court, in various precedents in the Debs line, has recognized that that kind of sovereign interest can occur in a variety of circumstances. For example, in the American Bell case, the court recognized that the United States could sue in equity to seek to void a patent that had been obtained by fraud, even though the United States had no reversionary interest or proprietary interest in that patent. It was acting on behalf of the nation as a whole to ensure that there couldn't be an acquisition of a monopoly that was based on fraud in that manner.
Well, actually, what I'm more interested in is, have you done something similar when a constitutional right has been involved? For example, there was much discussion about tort actions that were allowed in states involving the Second Amendment rights. I'm sure there were many opportunities in the area of race, particularly during segregation, to do similar things. Do you have any examples, not precedents, but examples of the national government taking part in or playing the exact same role or doing exactly what you're doing in other areas involving constitutional rights?
I don't have examples, but that's because I'm not aware of any circumstance where a state before has sought to prevent access to the ordinary mechanisms for judicial review that
Well, even if it's not
rights.
exactly the same, when a constitutional right is being frustrated by a state process, have you sought to participate in the manner that you're participating now because the supremacy of a U.S. law or constitutional right is not being respected?
Well, I want to be very clear, Justice Thomas, that we're not asserting here an authority to sue just because the state enacted an unconstitutional law. Ordinarily, that wouldn't present the same grave threat to supremacy because under Section 1983 or Ex parte Young, there would be a swift pre-enforcement remedy in federal court. And so the interest we're asserting here isn't intrinsically tied to the underlying substantive right at issue. It's tied to the fact that the state has structured this scheme in a deliberate attempt to prevent federal courts from doing anything about the constitutional violation. And because a state has never before crafted an enforcement scheme like this, there's not been the kind of situation that would prompt the United States to intervene in this manner.
General Prelogar, could I take you to one of the other questions that you started with? In these extremely unusual, unprecedented circumstances, you said the court is not powerless to craft relief. Well, you heard the last argument, and much of the last argument was all about, like, what would relief look like, and how should we craft relief if relief were appropriate? And there were, is it an injunction against the clerks, or is it an injunction against the state AG, or is it an injunction against fill in the blank? How should we craft relief?
I think the appropriate relief here is the relief that the district court entered. The court enjoined Texas from implementing SB 8 and enforcing it in any manner. And then the court went further to identify all the various stages of the SB 8 enforcement proceedings where that injunction would operate to stop the threat of those enforcement actions that have chilled the exercise of the right. And there were three relevant features. First, the district court said that the injunction would appropriately bind those SB 8 plaintiffs who actually choose to exercise the state's enforcement authority. And so those who actually file suit, thereby act in concert or active participation with the state. Second, the district court recognized that in these very unusual circumstances, it was also appropriate to bind the clerks and the judges who are being used as part of the machinery of this apparatus to impose the substantial chilling effect through the SB 8 enforcement actions. And finally, the district court recognized that the injunction would reach on the back end any effort by state officials to enforce those judgments because that too would perpetuate the constitutional violation. So I think we have the model already. It's the injunction the United States obtained in this case, and it's intended to provide full and complete relief against the threat, the grave threat that SB 8 is posing to the supremacy of federal law right now.
And if there's some fear that the law we make about how to craft relief will apply in other cases where it's not so necessary, what would you say, what would you do to ensure that that did not take place, to essentially cabin this kind of relief to the peculiar circumstances of this case?
I think it would be appropriate to cabin it in two ways. First, in recognition that ordinarily it is far more appropriate to enjoin the upstream enforcement agents who would be bringing cases to the court in the first instance. That is the ordinary way that an ex parte Young action proceeds, and if the state had not specifically sought to thwart that mechanism here by outsourcing the enforcement authority to the general public, that kind of injunction would have been appropriate. The problem is that the state has specifically, by delegating to members of the general public this enforcement authority, it's specifically made it impossible to determine in advance who is going to become an SB 8 plaintiff, who is going to actually choose to file suit. And I think in that circumstance, injunctive relief that prevents the state court proceedings from going forward is appropriate. And then the second limitation that I think the court could articulate is that this is the rare case where the mere existence or threat of the litigation is itself causing the constitutional harm. It's the flood of SB 8 enforcement suits that could be filed that is chilling the exercise of the constitutional right today. And it's not normally the case in an ordinary suit that the mere prospect that there could be a case filed would create this kind of profound harm and chilling effect on constitutional rights. But that was Texas's intent here. That was its clear purpose, and it's the actual effect, because right now in Texas, that constitutionally protected care is not available.
General, I appreciate your point. Texas has done everything it possibly can to try to make it difficult for abortion providers to vindicate their rights under our precedents. I get it. I think it's a forceful argument. But I think we have to be concerned about the implications of the mechanisms that you propose for providing some kind of relief. A lot of your brief and all the other briefs that have been filed against Texas in both of these cases suggest that we should issue a rule that applies just to this case. But that's inconsistent with the rule of law. When we decide a case, the rule that we establish should apply to everybody who's similarly situated. And if you look at the particulars of the enforcement mechanisms, they are unprecedented and they provide cause for concern. And so I'd really like to hear your explanation about why they're appropriate and how they can be limited to this case. Start with the judges. It's unprecedented, and it is contrary to our system of federalism, to enjoin a state judge even from hearing a case. When has that been done, and how can that be justified? The judge is a neutral arbiter. The judge is bound to apply the Constitution. How can you enjoin a judge from performing a lawful act, which is the adjudication of a case that is filed before the judge?
Well, I want to be perfectly precise that in our case, the district court enjoined Texas and found that that injunction could properly reach the state court personnel who would be then exercising the state's authority.
Well, Texas is an abstract entity, and an injunction has to apply to people. Yes, there are instances where a state has been enjoined, and what that means is that everybody under the control of, let's say, the state, everybody who has to follow what the state attorney general says has to comply, and the state can pick, can work out the way that would work. But that doesn't apply to state court judges.
Well, I certainly acknowledge, Justice Alito, that an injunction that would bind state court judges is extremely rare. It's not unheard of, and I think in the unprecedented facts of this case, it's appropriate relief.
Well, judges have been enjoined. Let me just interrupt you. Judges have been enjoined from performing unlawful acts. But here, the act that they are enjoined from performing is a lawful act. How can that be justified? Let me give you this example. Suppose an action is brought under SB 8 in federal court pursuant to diversity jurisdiction. Let's say a woman sues a doctor who has flown in from another state to perform the abortion. Would the district judge in this case have the authority to enjoin another district judge from even hearing that case?
No, I don't think that the injunction could properly reach the federal system. I don't think that there is any realistic possibility that any of these suits could possibly proceed in federal court, because the distinct feature of SB 8 is that the plaintiffs who are authorized to sue need not have any injury or suffer any harm from the prohibited abortions. And so I think the idea that there would be a proper basis for Article 3 jurisdiction is lacking.
Well, it's certainly possible to think of cases where there would be federal jurisdiction. A woman sues an out-of-state doctor in diversity under SB 8 for physical or emotional harm suffered as a result of the abortion. There's injury in fact, and the amount in controversy could be met. So your answer is one federal judge can't enjoin another federal judge. But a federal judge can enjoin state judges because they're lower creatures. That's the answer?
That is not what I mean to suggest. Here, the injunction runs against Texas, and the state court judges in Texas are being utilized by Texas to effectively create an apparatus that is so lopsided, so procedurally anomalous, and so hostile to constitutionally protected conduct that the mere existence of the suits, no matter how the judges adjudicate them, create the constitutional harm by chilling the conduct. And so we are not suggesting that that the judges would do anything other than actually follow federal law here. We think each and every one of these SB 8 suits would inevitably be dismissed because the statute is so clearly unconstitutional. But that doesn't remedy the constitutional harm because the constitutionally protected care isn't being provided in the first place.
General, to achieve this injunction against the state courts, do we also have to overrule Ex parte Young, where we said, and I'll just quote the relevant bit I've got before me, it's an injunction against a state court would be a violation of the whole scheme of our government. The difference between the power to enjoin an individual from doing certain things and the power to enjoin courts from proceeding in their own way to exercise jurisdiction is plain, and no power to do the latter exists because of the power to do the former. So do we have to overrule at least that aspect of Ex parte Young?
No, Justice Gorsuch. I think that aspect of Ex parte Young has to be read in the context of the court's recognition there and the whole thrust of the opinion that the appropriate relief would run against the enforcement agents themselves. I
understand that, and that was Justice Breyer's point earlier. But Ex parte Young also said this. And I think that's just, am I wrong? How do you reconcile saying you can never enjoin a court with saying you can here? Something has to give, doesn't it?
Well, I certainly think that it is not uncommon in equity to have relief that is targeted to prevent a suit in law from proceeding. I acknowledge it's unusual to have that relief run against the judges themselves, and if this court has concerns with that approach, I think that the court could rightly recognize that the remedy here could focus on the clerks engaged in the ministerial task of docketing the cases, and as our injunction does, against the SB 8 plaintiffs who are actually exercising the court's enforcement authority. But I do think that the court's statement in Ex parte Young has to be read against the backdrop of this court's recognition that there would be otherwise effective relief available. And what we're confronting here is a situation where it's very difficult to find that effective relief by design because Texas designed the law specifically to thwart it.
General, do you agree that there are instances in which no federal forum is available to adjudicate a federal right?
Yes, I do agree that that is sometimes the case.
You also agree that it's sometimes the case that a federal right can only be enforced defensively and not in a pre-enforcement challenge?
Yes, that can be the case.
Can you tell us what are the elements that must be necessary for you to have to seek the kind of equitable relief that you are seeking here? Would it be limited to cases where every single one of the characteristics of SB 8 that you mentioned are present? Must they all be present? And if that is the case, is this really what you're seeking, a rule for one case?
I don't want to suggest that every single feature of SB 8 would necessarily have to be replicated, but I think that the overall inquiry would have to focus on whether the state has deliberately sought to prevent any effective means of judicial review. And here we have it both with respect to federal court. Of course, the state has sought to supplant the traditional 1983 action, Ex parte Young action, but we have it on the back end as well, where the state is trying to purposefully make these SB 8 enforcement proceedings so anomalous, procedurally anomalous, and feature rules that are so stacked in favor of plaintiffs and defendants that the clear purpose and actual effect has been to chill the right. And I think that this is a response to Justice Gorsuch's questions as well, because although it is true that sometimes there's not a federal forum to raise a federal claim, for example, with defamation, it's not the case that in those circumstances the state court proceedings are heavily weighted in favor of the plaintiffs with the evident intent to chill the speech from occurring. And the proof is in how this has actually worked in practice, because defamation actions haven't meant that no speech occurs.
Well, counsel, but we've created a whole substantive law of defamation out of concern for chilling effects. And why on that theory wouldn't we go one step further? For all the reasons you've provided, they're good reasons, and I think Justice Alito's said they're strong arguments. Why wouldn't we do the same thing for that other very vital and important right or the Second Amendment right, or the right to free exercise of religion. They're all, we don't get to pick and choose among our rights. We're supposed to enforce them all equally. Why does this one get special treatment?
This law is different because it has taken the ordinary state court mechanism that might be an appropriate way to vindicate the rights, whatever they are, and it's purposefully sought to obstruct them.
You'd agree that tort laws for defamation have a chilling effect.
Yes, but they have.
And you'd agree that gun control laws also have a chilling effect.
They can, but not in the same way that
And you'd agree as well that
operates.
laws restricting the exercise of religion can have a chilling effect.
I'm not denying, Justice Gorsuch, that those kinds of laws can have some measure of chilling effect on the margins, but they look nothing like this law.
You're not suggesting, General Prelogger, that this right is different, are you? If this exact law were issued by a state that wanted to be hostile to gun rights, your argument would be the same, would it not?
It would be exactly the same, because the threat here is to the supremacy of federal law that's accomplished by trying to cut off the channels of judicial review that Congress recognized in Section 1983 would be vital to vindicating federal rights, whether that's Second Amendment rights or rights to religious liberty or here the right to abortion.
Well, doesn't matter that it's the abortion right. How about the issue of severability? You want to enjoin every action that's brought under SB 8, even though some of them would not violate Roe or Casey. And I guess the justification for that is that in the abortion context, as we held in the prior whole woman's health case, severability doesn't count. Normally, we pay attention to severability clauses, but I guess when it's abortion, if there's one provision of a statute that's unconstitutional, the whole thing sinks. Is that your position?
Well, our position is that the district court rightly applied this court's decision in Whole Woman's Health versus Hellerstadt and concluded that it would effectively amount to legislative work to walk through SB 8 and try to parse it provision by provision and application by application to determine which applications would be constitutionally permissible.
Well, is that what you want us to do if we find one provision of some massive federal statute unconstitutional down the road? Well, it's too much work to go through them all. We're just going to strike down the whole thing. You want us to do that?
The difference here, I think, that the district court recognized is that it would actually require rewriting the statute to try to reach those lawful applications. And I think in particular in this preliminary injunction posture where the court was acting on an emergency basis, that kind of parsing wasn't necessary. But if this court disagreed, I think all that would show is that the court should confine the injunction to the applications that are unlawful under Casey and Roe and make clear that the only acceptable implementation of this would be with respect to post-viability abortions. And, of course, Texas already separately prohibits post-viability abortions. The providers don't provide them, so I don't think that would have any actual real-world effect.
Can you go back to Justice Thomas's question? Imagine those columns there are filled with the California Civil Code. And let's take out those parts that don't deal with private people. So what we have are property and torts and so forth. And someone in your office says, I've been reading that. Don't ask me why. But I found 19 provisions here that I think are unconstitutional. Let's go bring a case. Now, if we accept your argument, I guess that person has a good point. I'm a little nervous. So far, what you've said to distinguish this one is you said, but here Texas purposely did this. Boy, that raises a whole other set of issues, as you well know, when you say the legislative history counts, blah, 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 blah. Okay? But you say, but they're not giving a good forum in the state to test out the constitutionality. And now I think about the California Civil Code or the Procedure Code or 15 other things. I don't know. You know? Is that the test? Have you sat down and thought through what are the implications of the test, or is it that the federal government, no matter who's in charge, without a statute, whatever party, whatever president, can just go and intervene in any case, can bring a federal case whenever they think a state law is affecting private people, is unconstitutional? And if not, what's the test?
No, Justice Breyer, we are not urging a broad authority to bring a suit like this in the circumstances that you identified. And I think that there are two critical distinctions here that separate those circumstances from the ones we confront with SB 8. First, here it is perfectly clear that Congress intended to have a federal court forum for the vindication of this type of claim through Section 1983, and the state is purposefully trying to manipulate it through the delegated enforcement authority and avoid that federal court forum. And second, with respect to the state court proceedings, it's not just that these proceedings, in my estimation, deny a fair forum. It's that by their very design, with respect to each and every procedural and substantive rule, they display open hostility to federal rights and try to prevent any effective forum to get statewide relief, declaring this law in violation of this court's precedents.
Thank you, counsel.
So I kind of lost track of time. I mean, this is pretty engaging stuff. I'm going to go ahead and stop us there. I'll make a note that we're at the 26:10 mark. There's a lot going on. So I'll just highlight at least three big things. First is this continued reference to Section 1983 and Ex parte Young. Ex parte Young was a prior court case, and I will try to find a link to it so those who are interested can find it on the slides. Secondly is the kind of the back and forth between Justice Gorsuch and General Prologer, and just like he didn't like let her speak, which I thought was pretty rude. So that's more of a style as opposed to substance. And I think the honing in on this question of like, how does the federal court system and the federal government say that you can't or that you can tell state judges what they can and cannot do? So we'll see how this evolves in the coming weeks, but it's just overall really fascinating. So I'll go ahead and stop the recording, and then we'll have our discussion for a few minutes, and then we'll call it a night. So thanks to those of you who took the time to listen in. Appreciate it. Have a good night.